Okay, welcome. This case is People versus Imagine Assi. And I want to congratulate all of you for being here despite the weather. You know, this is a tough crew, and we appreciate it. So, anyway, would you like any rebuttal time?
3 minutes, Your Honor. 3 minutes.
Yes, sure. You've got it. Go ahead.
Okay. Good afternoon, Your Honor. Jan Post for Appellant Nazim Assi. Mr. Assi's actions on October 8th, although heinous, cannot be considered a hate crime because New York's Hate Crime Act did not become effective until 2 days after his actions. The general construction law governs the determination of an effective date of a statute, and that specifically provides that when a period of time within which an act is authorized or required to be done ends on a Sunday.
Doesn't that really deal with things like where you have to make a filing or a payment and it excuses, the performance of that for
Well, Your Honor, that's certainly what the courts below found, but I don't see any
This is different. This is the onset of criminal liability. Isn't that a different, different contextual setting for this?
I don't think so, Your Honor. I disagree with the courts below. The statute itself does not say that.
But doesn't the general construction law talk about where the context shows that a different meaning is intended? That the GCL 110?
Yes, Your Honor. However, if we look beyond this particular statute and look at a penal statute that would require some act to be done, such as the obtaining of a license, then it seems to me that if somebody is going to be penalized for not obtaining a license within 90 days and the 90 days falls on a Sunday, I don't think anybody would disagree that the person gets until Monday.
But the words of the statute are required or authorized. What's the act required or authorized to be done in this case?
Well, that would be the question. Is this Court going to define act as voluntary conduct? Then it's my position that in this case, it would have to be the criminal conduct. I mean, my base
But the criminal conduct was at no point either required or authorized to be done.
But then if you take it back and you say the act is authorized to become effective, then the act can't become effective until Monday or Tuesday.
Well, what's to become effective is the statute criminalizing the act. That's what's to become effective.
Yes, Your Honor. And there's nothing in that statute that would require taking it out of the situation where the act is to become effective within 90 days.
Is the conduct any more excusable on Sunday than any other day?
Well, no, Your Honor, but that's not the point. The point here is that, first of all, the underlying acts are criminal no matter what day they take effect. Second of all, we're not saying they're no less criminal on a Sunday. We're saying on that particular Sunday, the notice requirement of the effective 90 days had not yet run because it fell on a Sunday, and therefore it was extended to Monday.
Do you have any case law to support your position?
Absolutely not. There's no case law to support my position or other than the decision below to dispute my position. This is a rare situation.
There are quite a few other penal law statutes that had, when they were enacted, if you counted the days, they would have become effective on a weekend.
Yes,
Do you know if any of those were not enforced on those alleged effective days?
Apparently, no one violated any of those particular statutes on the Sunday and then challenged whether or not the statute had become effective that day. The legislature has the authority and has in the past dictated that statutes become effective on a Sunday. They could have done it here. Instead, they did not amend this statute. They didn't dictate what date it would become effective. They left it up to the general construction law, which applies to penal statutes. If it applies to one, then it applies to all.
What about the provision that says that the consolidated laws aren't supposed to be construed to affect any provision of the penal law? You say that doesn't apply?
Well, Your Honor, my reading of that section, Section 101, clearly was meant to limit its application to penal laws already on the books when the general construction law was put
Adopted?
into effect. It was never intended to act forward, and it never has. In fact, this court and lower courts have used the general construction law to interpret provisions of the penal law. And again, if it applies to one, then it has to apply to them all.
Do you know if the situation's ever arisen in another state?
I could not find any situation, any case law that, as I said, either specifically supported. It's a unique situation, and in fact, and it's not a floodgate situation. It's one crime on one day. Obviously, anything that occurred on Tuesday, October 10th, would be a hate crime. So Mr. Assi was the only person arrested on the 8th, and therefore the only person that this particular argument actually applies to. And as I said, we don't know. Apparently, no one's either been arrested on the 90th day, which happened to be a Sunday, and challenged the effective date, or they've been arrested and haven't challenged it, because there's no case law either way on this.
So what should he have been charged with? Aggravated harassment in the first degree?
Absolutely, Your
The
Honor.
E felony as opposed to D felony?
Yes, and in addition, we're not saying that the attempted arson or the criminal mischief in the third degree, he was clearly chargeable with those crimes. The hate crime statute merely is a sentence enhancement. His actions were criminal. The question is whether they were criminal as a hate crime prior to October 10th, as opposed to October 8th when he actually acted.
Go ahead.
You're also, I think, arguing that the statute, if we disagree with you on the effective date, doesn't apply to religious property.
That's correct, Your Honor.
How do you reconcile that position with the definitional section that defines person as incorporating religious corporations?
Your Honor, are you talking about the basic penal law section?
Section 10.
That, well, my position
Subdivision
is
7.
that that definition certainly shouldn't apply for two reasons. One, corporations cannot acquire the attributes such as race or religion that the Hate Crime Act is directed at. Moreover, that's
But the Hate Crime Act doesn't say the victim's race or religion. It says a person's race or religion. Right?
exactly a person. But the point is, can a corporation have a religion? Can a corporation have a race? No. I mean, that's an awfully narrow view of what a person would be, because in addition, not every religious group is incorporated. So if you accept that it was a corporation, then you have to accept that a hate crime directed at a religious group that had not incorporated themselves was not, in fact, a hate crime.
What about 48505B? Isn't that an alternative theory, not really dependent on attacking or targeting the person?
No, Your Honor. You see, it's interesting the way New York State Hate Crime Act was written. It was modeled on the Wisconsin Act. But when they wrote it, they took out of the Wisconsin Act the against property in the title. They also, in subsection B, took out of and purposely it selects the property. That's in the Wisconsin statute that the Supreme Court upheld. It's not in New York statute. The only indication in New York statute that property crimes can be or are supposed to be or desired to be hate crimes is the list of offenses.
Yeah, 48505.3.
Right, but you
why is
must-
that not an indication of the intent?
Because you have to modify the list of offenses with the purposely selects the person. Since New York took out the purposely selects the property, it's not in the statute. So you have to read New York's hate crime as saying purposely selects the person and then damages property. Can arson be a hate crime in New York? Absolutely.
Isn't this a prototypical crime against persons and beliefs?
Yes, it is, Your Honor.
No, it's targeting property.
But that's where we're all struggling. In this case alone, there are 4 definitions of what a person means. The trial court told the jury that it was any building or structure. That's so ridiculous that even my adversary doesn't adopt it on appeal. My adversary says it's a corporation. Well, if it is a corporation, then where is the evidence that Mr. Assi bore animus against a corporation? There is no evidence of that. The evidence of
But
his...
where does the statute require that?
Because the statute does not say intentionally selects the property. It says intentionally selects the person and then lists a bunch of offenses, including property
What
offenses.
about his quotes as to what he says, who he's trying to,
Yes,
what this
Your
is all
Honor, his
about?
animus-
What does that say to you? Where is the animus towards the blank rich Jews of Riverdale? What's that about? What does that tell you as to his animus?
That tells me that his animus is directed at the rich Jews of Riverdale. It does not tell me that his animus is directed at the corporation of this synagogue or even the congregants of this synagogue.
But I don't
If
understand
this had occurred on a day where there were services being held at the synagogue, would you have that same argument?
Probably not, Your Honor. But the point is, his animus was the rich Jews of Riverdale. As amici point out, they try to claim that a person is defined as the community at whole, some amorphous population. No, it has to be the direct victim. Again, property crime can be a hate crime.
Is there anything in the bill jacket that supports your reading of it?
There's
Because
not-
there's quite a bit in the bill jacket that seems to go the other way.
Well, Your Honor, no one's denying that the legislature wanted property crimes to be hate crimes. Unfortunately, they left out, both in the title and in the body of the Act, the very important language that said purposely selects the property.
So they made a mistake, you think? Is that your argument, they made a mistake, or was it deliberate?
I have no idea, Your Honor. My argument is that you have to look at the wording of the statute, and without that language...
There's no way it can be interpreted, you're saying, without that language.
Without that language, property crimes have to be defined as hate crimes in connection with the person. Who was the person intentionally selected?
Even though the legislative history would seem to indicate the opposite.
Your Honor, if it was their intention and they didn't do it, I mean, they've modeled it on a statute. I can only think that perhaps it was deliberate. It's in the Wisconsin statute
Okay,
in two
counsel.
places.
Okay,
Thank
you'll
you.
have rebuttal time. Counsel?
Good afternoon, Your Honors.
Good afternoon.
Mr. Coddington for the people.
What about that, Mr. Coddington? Is there just did the legislature make a mistake, or?
No, I think the legislature enacted exactly what they wanted to do. As Judge Graffio pointed out, there's lots of legislative history about swastikas on synagogues and burning crosses.
What about your adversary's argument about missing words?
Well, there's no missing words. The person here is a corporation, or arguably, person here are the rich Jews of Riverdale, and he committed a crime against their property by defacing their synagogue. I mean, this is very much a hate crime directed at Jews.
The property wasn't the property of a Jew. It was the property of a corporation.
Of a religious corporation
Yeah.
incorporated as a synagogue. So, I mean, as much as a corporation can be a Jew, this one is a Jew.
True enough, but a corporation actually can't be either a Jew or a Christian or an atheist. A corporation's not a person, right?
Well, it's incorporated as a religious corporation. I mean, we were talking about the business corporation law. I'd agree with you.
So is that what the case turns on? If this were a Jewish community center owned by a non-religious, non-profit corporation, the conduct would not be a hate crime?
No. I mean, this conduct, my position, is motivated against the rich Jews of Riverdale. If there happens to be, say, a bodega with rich Jews of Riverdale sign on it, and this guy throws a firebomb at it intending to intimidate the rich Jews of Riverdale, that's a hate crime.
Even if the bodega is owned by an ordinary business
Yeah,
corporation.
right. Or ordained by a Catholic, whoever. Yeah, makes no difference. I mean, it's the motivation. And here I think the record is pellucidly clear that the motivation here was a political statement directed at the rich Jews of Riverdale. That's a hate crime. This is what the legislature meant to criminalize, and that is what they wrote. It's a person, and it's directed both at the corporate person and at the larger community, as the appellate division found. And the legislature quite clearly intended this to be effective on October 8th, 2000, a Sunday. It seems to me that question is controlled completely by General Construction Law 101 and 110. I mean, 110 says you can't amend the penal law unless you explicitly so say, and shall be effective 90 days after the governor signs it is part of the penal law that the legislature enacted, counsel's argument amends that to 92 days. General Construction Law 110 says you can't do that. General Construction Law 101 says you can't do that. And General Construction Law 110 echoes that sentiment.
Did you find any authority for your position?
The only authority...
Kind of unusual that this hasn't come up before, isn't it?
Well, the best case on point is Bloomingdale, 1888. And good law since then, Your Honor. This was based on, I guess, the Bloomingdale decision. There's some authority, of course, in Section 41 of the statutes, which isn't case law. But it says the legislature can do anything it wants, including making conduct criminal on a Sunday. And it makes perfect sense. I mean, unlike the commercial transactions, which is what the general construction law is really aimed at, I mean, you know, crime doesn't work a work week.
What about a statute of limitations? Statute of limitations were to run on a Sunday, would it be extended to the Monday?
Well, in terms of charging a crime?
In terms of charging a crime or bringing a civil proceeding?
Bringing a civil proceeding, I think it probably would. As in terms of
What
charging the crime, I don't know. My gut reaction to that is it just might. Just might. I mean, that's different because, I mean, that's an act that can be done beforehand. I mean, this act could not be effective before October 8th because the legislature said so. I mean, if we blow the statute of limitations by not filing our indictment on the Friday before the Sunday, then I think we may be out of luck. I'd have to research it to be sure, but that's my off-the-top of the head opinion for that one.
There was a Batson issue here, too. Do you want to?
Sure. Well, I think, again, this is clear. I mean, age groups just simply aren't suspect classes. Suspect classes are, you know, race, gender, I guess in some respects religion, things that not everybody shares. All of us and every member of this jury was age 18 to 23 at some point in his or her life. It's just not a suspect class. You said so in Marasco v. Como. The Supreme Court said so in the Kimmel case and Gregory v. Ashcroft. It's just, you know, everybody is that age at some point, so it's just plain not discrimination. Granted, the legislature enacted some provisions in the executive law, and if they want to extend the constitutional protection through statutes, they're free to do so, but they haven't, and it isn't this Court's promise to write the statute for it. Unless there are any further questions on anything, I'll surrender the balance of my time.
Thank you, counsel.
Thank you.
Appreciate it. Counsel Roberta?
Yes, just 2 points, Your Honor. With respect to point 1, Bloomingdale is not, is not authority. That case merely held that a statute can take effect on a Sunday because there the legislature had specifically decreed that it take effect on a Sunday. And with respect to point 2, I think my adversary and I very clearly, he points out where we differ. A firebomb against a bodega owned by a Catholic person, known to be a Catholic person, while yelling, "Get the rich Jews of Riverdale," would not be a hate crime, in my opinion. Thank you.
Okay, thank you.